Hello, veterans, Decade VA employees, everybody watching here at Veteran Lang YouTube channel. Welcome and thank you, as always, for your support. Thank you for all who have been adding some comments and chatting on the videos. It's always fascinating to see the different perspectives and get the insight from others in the views that they have. I feel that's the only way we're going to succeed in our mission here of educating and trying to make the process smoother between veterans and VA alike, is to see the different points of view, see where everybody stands, and see where we can make those adjustments. As always, I'm your friendly VA credit attorney, Matthew Lang, here with another video. Hey, we're going to talk about a topic today that I think needs to be ironed out because I'm seeing it way too often in my professional opinion here. Now, keep in mind, I do see the bad and I do see the ugly. I don't usually see the good. I mean, if everybody's getting granted, they're not typically talking to me. So understand that I am only seeing bad and the ugly, and I'm not trying to say that this is happening all the time inside the VA, but it's enough from the cases and the veterans that we've helped that is leaving me concerned and really frustrated with the idea that it's even happening. So what am I talking about? Well, I'm talking about examiners, VA examiners in particular, the contractors even that the VA uses, who write up medical opinions for veterans' claims. And those medical opinions are, one, inadequate completely underneath the laws, but mainly the idea that they like to use nationwide, I've seen this, the terms no literature exists to show a relationship between the two conditions, despite the fact that there is a well-known public relationship and medical community relationship and a ton of literature that supports the relationship between two conditions. Now, we've kind of got a little further into that. Recently, I've noticed that they'll start saying that, oh yeah, sure, there's some literature. But even though there's literature that supports the connection and everything supports it, it's still not connected. We'll address that later on, but let's focus on the idea of the no literature exists, because even I've got Google. So I'm going to go through just a few of them I've got written down here, see if we can hash out a solution to this. Hopefully some examiners are watching as well. I know there's plenty of good ones out there. Maybe we can recruit their help too in the process. Maybe there's something I'm not understanding here. I'm just the legal side. I'm not the medical side. So maybe there's a misunderstanding between the two sides. So what could be some possible reasons why the VA examiners keep saying no literature exists when it does exist? Well, number one, I'm going to say they may be using the wrong standard. The idea that there's a scientific consensus instead of a VA's benefit of the doubt standard. So the courts made it clear that the medical principle does not have to reach scientific consensus. That's too high of a bar. That's too high of a standard. And I believe what's happening is we're saying it's too high up here. So to say actually no literature exists may not be meaning no literature exists. It may be that they don't feel that there's this higher standard level of literature existing. Now, that completely goes against the approximate balance of benefit of the doubt rule underneath the legal side that is supposed to be considered and taken. Now, keep in mind, though, via the approximate balance of the benefit of doubt rule and the equipoise rules, those are all for you to make decisions on and not the examiner, as those are legal questions. So keep in mind, VA benefits law does not require a veteran to prove medical causation to the level of a medical school textbook. The standard is not scientifically certain. The standard is at least as likely as not. Now, a second possibility here of why they may be using this term of no medical literature, they may be answering the wrong question. Typically, I'm going to say that's a lot of what I see. Many negative opinions are answering only whether one condition caused another condition. But underneath the CFR, and from what the courts have hashed out for us multiple times, the examiner and the VA also have to consider whether the service-connected disability aggravated the other condition. Now, what we usually see is the VA has designed a DBQ that doesn't even ask the question for aggravation, so the aggravation question doesn't usually get asked. And ultimately, we find the examiner saying that there's no medical literature showing causation only, while there's medical literature showing aggravation. And then that aggravation piece doesn't get addressed. So maybe the examiners are looking for the wrong literature and they're not finding it. That could be our second problem. Now, this is fairly common because I've noticed the same responses across the nation. So I suspect that there's a use of some boilerplate instead of some real rationale in these write-ups. Perhaps a statement like no medical literature supports this claim is often conclusionary unless the examiner explains the search, the evidence reviewed, and why the cited literature does or does not apply. So again, the court has said that medical opinions must support its conclusion with analysis. And the VA, including the Board of Veterans' Appeals, can weigh against contrary evidence, including why cited studies are persuasive or unpersuasive. But the idea here is that the examiner still has to provide a rationale that speaks to the idea of what evidence was reviewed, what evidence was looked at, what literature was reviewed, what did they do in their search, what was... You can't give conclusionary statements is the point, is what the court is telling us. Let's move on to the next possible one here I have written down. Perhaps the examiners are treating association evidence as worthless. So medical studies often discuss increased risk, association, correlation mechanisms, or aggravating pathways. Examiners sometimes dismiss those studies because they are not definite proof of causation. But VA law does not require definite proof. The court again has explained that medical literature can affect the probative value and adequacy of a medical opinion, and that the VA must address qualifying or contradictory aspects of medical text evidence when they are raised. So again, what we're really seeing here is that the examiners may be putting veterans your claims to a much higher standard and ultimately saying that there's no medical literature because, again, they're only focused in on the idea of causation. But that's not the standard underneath the law. Medical literature does not have to say this veteran's exact disability was caused by the exact service-connected condition before it becomes relevant evidence. It ultimately just has to say there's at least as likely as not a connection. Now, another one that concerns me, and I'm really hoping it's not the case, but I feel that examiners may be using these terms of no medical literature existing because, well, they're not doing meaningful literature review. As a professional, they should be doing meaningful literature review. I mean, even I am held to a high standard to ensure that I know the rules, the updated laws, the updated literature in so many aspects. And even working in this realm and handling VA compensation claims, even I have to do research to understand the meaningful literature in the medical community before I can even argue it. So sometimes no literature exists appears to mean I did not find it. I did not look beyond a limited source, or I did not see it in the materials I usually rely on. That is very different from a medically defensible statement that no relevant literature exists anywhere. So a good opinion should say something like this. I reviewed X, Y, and Z sources. The studies submitted by the veteran addressed association, but not causation. They are less persuasive in the veteran's case because of A, B, and C risk factors. Now, did you hear how that, if put in further detail, in the X, Y, Z and the A, B, C spots there, was more than conclusionary? There's an actual rationale and statement that would go behind all this. And then we've got the weak opinion that we usually see is that medical literature does not support this. That's extremely conclusionary and and makes it sound like the examiner is incompetent, unfortunately, in my professional opinion, even though I don't believe they are, or I'd like to believe they're not, but it demonstrates that they may not be reviewing the medical literature or staying up to speed with the area that they're working in. So, veterans, I would definitely challenge your decisions if you see this written inside of your decision that the examiner has said no literature exists. One that we'll give you one last one here. One that could also kind of go with that is the idea that the examiner may lack the right specialty or expertise. And I feel like we've kind of caught on to this too as we help veterans with their VA compensation claims. Some secondary claims involve complicated medical questions, psychiatric conditions and cardiovascular disease, orthopedic gait changes, spine disease, medication side effects, metabolic disease, TBI and neurological complications, sleep apnea and PTSD, and so on. There's so many things out there. But a general examiner may be asked to opine on a highly specialized relationship, and they may not realize that that's what they're being asked to do. And perhaps the VA is not realizing that's what they're being asked to do. But the court has criticized reliance on an opinion where the medical professional themselves disclaimed expertise relevant to the question being answered. So when we look at these medical opinions that say no literature exists or supports the connection, we really start seeing who's writing most of those opinions. We see what their practice really is, and we see what those conditions are. And as we study that, it would appear in our, or in my opinion here, a professional opinion, that maybe some of the individuals being used to provide these opinions, at least on the contractor's base, is not quite familiar with the veteran conditions, and maybe some of that literature that is out there. And that could be causing some of our problems here. So I've given you a few thoughts here to work with. I'm hoping there's some additional discussion with some of this, especially with examiners out there, whether you be a nurse practitioner, whether you be a physician's assistant, whether you be a doctor or a specialist of sorts. I'm really hoping we can come together and fix this issue, because I feel like I'm seeing this way too often that it's becoming a number one issue. In VA, I can only ask that you properly fix the DBQ that's been incorrect for, I don't know, 13, 14 years, and ask the right questions, especially on the secondary. And then hopefully the examiners can understand more of the legal side as well as the medical side as we learn the medical side here on the legal side. And get through this hurdle here that's causing so many unnecessary denials to veterans. Because ultimately what's happening here is the VA is creating its own competition, maybe, and it's putting itself out of business. The idea is that, for me, by the VA's exams being so bad and the write-ups not meeting the standards of the law, that others have now stepped forward who want to do this right, have created businesses and have become experts, and are now having veterans pay for this work that, well, should be free to the veteran underneath the rules. But in order to get it right, that's where we seem to be, which ultimately is unfortunate, and individuals like myself have to really highly consider the use of those individuals, knowing that they are reading the medical literature, knowing that they are qualified, and making sure, one, that they are following the legal standard when they write those opinions prior to submissions of claims and appeals. So we do provide more of a quality check back here than it seems is occurring at the VA level. And I really hate to put it that way, but that's the appearance of what we have. But remember, I see the bad and the ugly. I don't see all the good. So I'm not saying that this is something that's happening to every veteran. I'm not saying this is happening to a level that is out of control. But I am concerned about the number of of times I am seeing this issue where it appears that medical experts are not quite experts, or they're not equipped to complete the task, or they just lack the knowledge, unfortunately. So anyhow, I appreciate your time. Again, as always, I wanted to point out this error that's out there, veterans, especially for you, if you happen to see it in your claims and your appeals. I wouldn't give up on your claims or appeals on that. I just, unfortunately, we just got uphill again, and we got to keep trying to get it right, and make the arguments, and maybe even sometimes look towards an independent expert who will tell you no if there is no connection, and tell you yes if there is a connection, and make sure that they do it right as well. But here we are. Here we are. This is the world we live in right now. So veterans, just remember, if you are denied a claim, check out veteranlang.com to schedule some time with myself. We can chat about that. Don't forget, you do have VSOs out there, veteran service officers. There's a lot of good ones I've worked with over the years. There's a lot of good ones I even talked to in passing. I do get the impression that they are quite overwhelmed, at least in the area I am in right now. But still check them out. Check them out. You also have other VA accredited agents out there and VA accredited attorneys you can find on the VA's Office of General Counsel website, where you can search for all VA accredited individuals. And if I recall right, I have put that link on the bottom or in the footer of my webpage, so you can find that easier as well at veteranlang.com. All right, everybody. I'll see you next Tuesday. Maybe we'll throw a special video in there or not if I get some time. But otherwise, have a tremendous, terrific Tuesday. I'll see you next week. Thank you.